We are starting now. Today is the 238th Friday group meeting. The speaker is our beloved Senior Advocate Mr. Rana Mukherjee ji, and the topic is RERA, the Real Estate Regulation and Development Act 2016. Rana ji even earlier also he addressed our Friday group, 124th Friday group meeting, that is the dated 30th August 2019. The topic was the impact of the pioneer judgment on home buyers and infrastructure industries. Sir, your contribution for YouTube channel 2000.
Benami Transactions Act also.
Benami Transactions Act also.
Earlier
At that time we don't have a recording.
That's right.
You are right. So that's one thing. Your contribution for YouTube channel is 2000, sir. US. Now, kindly address our Friday group, sir. Yeah.
Good afternoon, friends, and this is my third session in the Friday group. I must compliment Mr. Sheshu for, I call him Sheshu, he's an old friend of mine, G.Seshagiri for continuing with this effort of, trying to educate lawyers and non-lawyers of developments in law, or let's just say continuity of law. So the various topics, he picks up the topic and he tells some like us to prepare and give whatever little knowledge we have on any subject. So today this is a continuation of the pioneer judgment. In fact, when I delivered the last group on the pioneer judgment, right after the judgment was delivered, we were still trying to understand the impact of the judgment. Now, after 5 years, we have seen that quite a lot has happened, but a lot still has to happen. So let me start by, without going to the nitty-gritties of the act first, tell you that in India post-independence, the first necessity of a person was to have a secure house. So we are largely comprised of middle-class people, largely. The lower segment who are poor also, they aspire for a thatched roof on their house, on the head. They don't aspire for a larger place, but they take what they can afford. The middle class, like I was discussing with my juniors the other day, I think my parents' generation, including Sheshu, was the first one who came out of their joint family system and created nuclear families. So people are posted, because industrial revolution was happening fast in India in the 50s and late 60s. So they came out, and that batch started retiring, let's say, mid-70s onwards. So what was the necessity? They had to provide for a roof over their family, a shelter. Education was one very big area which they had to take care of. Now, how do you provide for a roof over your head? So either buy plots of land, which was available at that point of time. By late 80s, the pressure started mounting. So land started getting scarce. So how do you provide? So DDA came up with one policy of having multi-storied complexes, not very high, but which could house very many families. So DDA was the first. We already had a cooperative movement right from an act of 2012. The Delhi Cooperative Act came in 1956. They also had cooperative societies, and that was a big movement all over India. I'm talking about Delhi Cooperative because it is closer home. We can discuss about that. But despite all this, people were unsure of how to invest, where to invest, and what are the projects. So we didn't have real developers or let's say corporate sector entering this building activity. So we had small contractors who could rent out, say, 5 male ka building bana do, 6 male ka, we have 10 flats, and the owner would sell. Slowly by late 2000, there came a boom where this corporate started entering the building sector. And big corporates started acquiring huge tracts of land. So there would normally be a town planning act under which lands were allocated or would be allocated to such builders who would give a project proponent. And Then they would advertise there would to be built apartments for sale and give lucrative offers. You had bonuses, this, that, and the other. Then unfortunately, the world saw a crash in 2008-2009, mortgage crash, which is called the subprime. It impacted a little bit in India. Our banking financial system was very strong compared to other countries. We could withstand that crisis. But that effect started lingering on from 2012 onwards. Most builders started failing in their commitments. Some deliberately, because they had taken finances. Some accidentally, because of lack of resources. They did not have the wherewithal to really rotate their money. So some builders had actually transferred the monies collected from the allottees to buy other plots of land, and they started construction there. So each one of these were half constructed, unfinished products. We call it products actually. So an allottee or a aspiring house owner was left with no alternative but initially to file a suit. Now, suit would normally take a long time to be determined as to who is at fault, whether you have defaulted, whether the property builder is defaulted. Then someone came up with the bright idea of knocking the consumer courts. So the consumer court started taking charge, but the consumer court did not have that kind of machinery to really force the builders to comply with directions that complete the building within so and so. They used to pass orders, but largely the builders would fail. So till 2016-17, this was a state of limbo. Most of the orders were refund the money with interest. But some of the allottees were not happy because this was the only investment they had made. Or they had mortgages with banks, which was largely in the form of subvention agreement or whatever. So matters came to a head, and the Supreme Court, while dealing with one of these matters, which was, I think, Vikram Chatterjee and Nikhil Mehra, etc., they suddenly probed. Justice Deepak Mishra was then the Chief Justice. He said, why shouldn't we have them treated as financial creditors and treat this as a financial debt and get them included in the IBC scenario? So then came a spate of litigation. In the meantime, the RERA Act was enacted in 2016, but not all sections were notified. So notifications came in due course. Some sections were notified, some were not. This also had an overriding effect. The IBC also has an overriding effect. Then section 5.8 in the IBC was introduced, 5.8F, section 21A and 25. So this largely took care of the allottees of a building project to be treated as financial creditors. Therefore, they could also invoke a section 7 application and the IBC could be kicked off. Now, it was in that scenario when a huge challenge was laid, which was later on disposed of in this batch of petitions called Pioneer. The Pioneer citation, I think I've mentioned in that note. Pioneer they were confronted with 3 or 4 issues. One is, can you treat such a person or persons as a financial creditor? Number 2, since the RERA Act was already in force, how do you reconcile the two? So the Pioneer went into the nitty-gritty of the law committee report, looked into the RERA provisions and found, to his dismay, that most of the sections are not notified. The tribunals and the authorities were not manned by personnel. So they went ahead and said that no, this has to be treated and upheld the amendment to the IBC. And the IBC also in 25 or 21A and 25A said that one member representative of the committee of creditors would comprise of one home buyer, one representative. See, if there are 50 could not be part of the committee of creditors. So it was in that scenario that this started rotating, and the IBC kicked off in that sense that property allottees would come in as financial creditors. And the ingenuity of the NCLT and NCLAT, they had a concept called reverse CIRP. That means the project proponent would itself give a scheme before it was advertised for expression of interest. And they could come up because they would be like the MSMEs. They would be best placed to know what is the financial situation. They would offer haircuts. And there were 3 or 4 cases in which the Supreme Court upheld the reverse CIRT, which meant that you don't call outsiders. The project developer itself would give a revised scheme with timelines, and that in 2 or 3 cases got approved. In one such case which I was doing, the NCA NCLAT was not very convinced about the genuinity of the developer, but did not allow the reverse CIRT. One matter came floating to the Supreme Court. Justice Gawai upheld the concept, though he does not use the word reverse CIRT. See, of course, the concept that he is the same person, the same developer can be the best person who can really take the project forward. Because after all, the allottees were all clamoring for the flats. Now, Pioneer notes also that at that given point of time, there were 826 projects which were lying unfinished. But that should have been the NCR project, I think. All over India, there are N number of projects which are actually unfinished by developers who were overambitious, who had taken more than they could chew. The loans were mounting. So most of them, and some of them were also arrested. Some directors were arrested for non-complying. Amrapali is a case in example where the Supreme Court used 142 powers to really get NBCC to complete the project. Appointed Mr. Venkatraman, who is now the learned Attorney General for India, as the administrator over the project. He is still continuing, though he offered to resign, and set up a team which is now monitoring the Amrapali. But that's the IBC scenario. Now, Pioneer also notes that while the Consumer Protection Act, the IBC and the RERA are coexisting, and RERA has provisions in sections 87 and 88. One is overriding and one will be not in derogation of any of the act. So that means that then the Pioneer said that it's up to the allottee to select which forum they want to go. So it would not be termed as forum shopping. So then para, I think, 8089, sorry. 8089 of the RERA. I'll come to the section later on. So now allottees or hopefuls of getting an apartment had 2 or 3 forums. So they largely went out of the consumer protection jurisdiction. They started approaching the RERA tribunals and authorities. And I've taken some statistics out, and they show that there's some disposal which is happening. But the IBC has been independently very favorable for the home buyers because they have a timeline. RERA in contract restriction does not have a timeline. Executability of orders is also a problem, which I'll come to later on. In so far as the IBC disposal is concerned, we've seen very many projects being completed. All those companies goes into liquidation at the peril of the home buyers. Now, when we look into the whole idea of RERA, this is from the statement of objects we can see that it is a welfare legislation. And why do we call it a welfare legislation? Because it's for the benefit of certain people who have been, before the Act came into force, deprived of their fruits of labor. So if you look at the statement of objects of RERA, it gives an insight as to how the Act is designed to take care of such people who have invested in real estate and who are aspiring to, whether it's commercial or residential or otherwise, are aspiring to get their plot of land or their built-up house in a manner that they had agreed to by form of an agreement. So suits would largely follow the agreement. Even the Consumer Protection Act would try to invoke the clauses of the agreement to say that you have to do it within a specific period of time. But they fail largely in their attempt to give relief to the home buyers. Like I said, most of them were awarded with return of money with interest. So one such case which came to the Supreme Court is Oreo, where the Supreme Court segregates as to if a property is developed and built and occupancy certificate is received, then the home buyer cannot say I will not take it. They have classified a delay as to be what is reasonable, what is not reasonable. It was authored by Justice Chandrachud. He was not the Chief Justice then, but it was his authored judgment. So he segmentizes different categories of stages of home building and says that, see, if a property is developed, OC is received, then the home buyer cannot just walk out and say, no, refund me the money with interest, because the interest we recently argued a matter which is actually in the form of damages. Because it is a contract. The agreement does not say that only for late delivery there's a provision for grant of interest, which is a kind of setup. So they said that 9% interest is given, or else if you take that money, then they fix 9% as a fixed rate for return of that money. Then one argument came to the fore that, you see, now suddenly there is a surge in property prices. These are all artificially created. If you look at the website, properties which were largely at 1 crore 50 or something has slightly shot up to 3 crores, 4 crores. So one argument made in one such matter was that, see, we take the money back, and the home buyer, the builders are complaining that, see, I'm out of pocket, I have constructed. But it was a matter of fact that they already had resold that flat to somebody else at a much higher price. So their so-called loss was not that impactful for the home buyer sector, the developing sector. Now, so the Real Estate Regulation Act actually steps in to take care of. It says an act to establish the Real Estate Regulatory Authority for regulation and promotion of the real estate sector and to ensure sale of plot, apartments, of building, as the case may be, or sale of real estate projects. So project is defined in an efficient and transparent manner, and to protect the interests of consumers. This is very important. Protect the interests of consumers in the real estate sector and to establish an adjudicating mechanism for speedy dispute redressal, and also to establish the appellate tribunal, so on and so forth. This is very important to protect the interests of consumers. You see, in the consumer protection, very many cases they came up with this. The builders used to say, no, this person has bought it for resale, so he's not a consumer. A consumer would be who would actually take it under Section 2D, that he or she would take it for their own use and occupation. But that also got whittled down by the court, saying that it does not matter whether they buy it for resale or whatever. The point of impact is they have made payments for purchase of a property, you jolly well give it to them. Another case came up which was Loza Builders in Bombay High Court, where they said that this person had taken 4 flats. That also got settled by a judgment of Supreme Court, which Justice Deepak Mishra and I think Justice Khanvilkar. They said that again it does not matter whether he's bought 4 or 5 flats. If you contracted to give those 5 flats, you jolly well give it to them. So the Consumer Protection Act could still be kicked in. Despite that, this RERA Act actually now is a wholesome act. There are many loopholes in this act. The implementation itself is taking a long time. We are now 2024. 2019 was when the Supreme Court in Pioneer actually cracked the whiplash to say that please appoint members. You have to have members manning all over, because this finally land is a state subject. This act is under the Concurrent List. So they said that every state would have to frame their own rules and regulations. So Supreme Court finally found that Bengal, as usual, came up with a parallel legislation, which was called the Bengal? West Bengal Housing Industries Act. The last bit. But the Supreme Court struck it down, saying that, I'm sorry, you cannot have these 2 acts coexisting, which is repugnant to Article 258, and said that you frame your rules accordingly. To my understanding, they are still dithering over how to do their rules, because it was struck down in 2022. It is still not a very effective forum for West Bengal allottees. Now if you look at the basic area of operation of this act, let us take the definition clause first. It is very interesting inclusion of certain sections here. You see, we have the appellate tribunal is defined. We have a very interesting carpet area defined for the first time. See, in Bombay, normally when we discuss in Calcutta, the concept was that the built-up area, the carpet area would be common areas plus carpet area, so 30% reduction. Bombay was 25%. But Bombay later on, under their Maharashtra Development Act, Flat Building Act, they found that the carpet area included the common areas also. So what was projected for sale was actually much lesser than what the allottee was actually getting. That was also settled by the Consumer Forum in a matter which related to Loza developers, and that is being followed largely. So now they are following the carpet area which is defined under the RERA Act. We say that it means the net usable floor area of an apartment excluding the area covered by the external walls. So it is the true effect of the internal dimensions of a flat which form the carpet area. So a person who is applying for allotment knows fully well how much he is getting. And when I mean he, Joint Clauses Act says means she also. It's a matter of habit which we say, we keep on saying he. Then we have this person is also defined. Then we have the immovable properties defined and interest. Now the RERA has a higher rate of interest. It gives more than 10.7% in certain cases. Because there's a penalty also which the authorities can impose. And the appellate authority also largely follows this pattern. Then we have the occupancy certificate also defined, because this was a very contentious area under the Consumer Protection Act. They could not direct the authorities to issue occupancy certificate because that was not within the remit. So some of them tried to impede them, get them impeded, and some consumer courts took commitment from them. But this now has an occupancy certificate defined, which is mandatory, and they can issue directions to the authorities also, either the Town Planning Act or the local municipal laws, to say that you please give it, because this is how the project will then come to fruition. Then you have the cooperative society also brought within the fold of this act. Like that's why I mentioned the cooperative society movement. They have now brought in the cooperative society as a person, which is included under the RERA Act. So despite the cooperative housing society being active, very active, if you go to these areas near Mayur Vihar and all that, every plot was allotted at a lower rate by the BD or NDMC for cooperative society. They were earmarked under the Town Planning Act, and they got it at a much reduced rate. So these cooperative society would be formed under the Cooperative Society Act. They would come up with their own plans, building plans, and they would execute through a third party. So there was no forum like the authority here or the appellate authority which could govern. Only the cooperative register of cooperative societies could take care of any failure there. Then we have the prospectus is defined like in the Companies Act. Then we have these two very ZM and ZN, real estate agent and real estate project. So a project is defined. Now the project definition is very important. It says a real estate project means the development of a building or a building consisting of apartment, consisting, it's an inclusive definition, or converting an existing building or a part thereof into apartments, or the development of land into plots or apartments as the case may be, for the purpose of selling all or some of the apartments or plots or buildings as the case may be, and includes the common areas, the development works, all improvements and structures thereon, and all easement rights and appurtenance belonging thereto. So all these town planning acts, when they'll hand over huge tracts of land for development to some developer who is approved by the authority, they have to have these external development charges, internal development charges, roads are built, pipelines are laid. So they're all included, which are everything, nothing comes free. The authority would have to finally pay for it. Why should the developer pay for something that you are going to own finally? But they have to provide for it. For it, there are some charges. So this takes care of all these expenses also, largely. Then comes the registration of a project, which is very interesting. Now, please take this very carefully. If you have individual plot, you are developing it, the act will not kick in. But if you are going it through a real estate developer, for example, you have these now builder flats coming up. There, again, the real estate developer may be required. So it's very cleverly, if it is below 8, there's an exemption. So they make 6 flats or a flat or floor. So they don't need to register themselves so that they are out of the clutches of this act. So, but people are buying. So now what they are doing is they're not really investing in a project which is to come up. They are buying a finished product. So the Real Estate Act would not apply there. Now, if you see, there's an exemption under Section 3. Prior registration of real estate project with Real Estate Regulatory Authority. That's a mandatory requirement. Subsection 2 gives an exemption. So it says, notwithstanding anything contained in 1, no registration of real estate project shall be required where the area of land proposed to be developed does not exceed 500 square meters, or the number of apartments proposed to be developed does not exceed 8 in all phases. That was what I was trying to emphasize. That so these builders are also smart people. So they say, "Oh, hum 6 banate hain. I'll make 7." So they don't come within the sweep of this act. So below 8, below 500, you don't need to register as a real estate project developer under the Real Estate Act. Then you come to the application for registration set out, grant of registration, and legal title. The developer who is building has to satisfy the authority before the registration is done that he or she or that corporate entity has legal title to the land. So legal title is very important. That's why when I had done the Benami Transactions Act discussion, now because of registration through Aadhaar card, etc., now the Benami transaction has gone down to a great deal. So Benami purchases have gone down. So you buy earlier in the Delhi area at least, municipal areas, if you had one flat under cooperative society, you could not offer another flat, not the family members. But that restriction is not there under these because these are largely private funded projects. They are not the government projects that come up. So then there's a grant of registration. Now we skip straight away to the registration of real estate agents are also very important under section 9. Then we see that functions of real estate agent, this is very important. What are the functions? Every real estate agent registered under section 9 shall not facilitate the sale or purchase of any plot, apartment, so and so in a real estate project or part of it being sold by the promoter in any planning area which is not registered with the authority. So if you do that, it's a fraud on the statute. You can get caught. Therefore, the due diligence also is taken care of by these sections. So a person when he is applying under a real estate agent would be assured of this. So these disclaimers will have to be set out in the prospectus, which is held out. Correct? Then the functions and duties, which is chapter 3 of a promoter. This again assumes importance because this act is now in force, section 11. The promoter shall, upon receiving his logging ID and password under clause A or under so and so and 5, create his web page on the website of the authority and enter all details of the proposed project as prescribed under subsection 2 of section 4 in all the fields as provided for public viewing, including details of registration, quarterly up to date, the list of numbers and types of apartments of the plots as the case may be booked, quarterly up to date list of approvals, etc., etc. It goes on. And then subsection 4 says, promoter shall be responsible for all obligations, responsibilities, functions under the provisions of this act and rules. And it goes on to say what are the necessity requirements that the promoter has to fulfill to continue with the project. If you don't do this, the registration may get cancelled. So if someone complains, the authority would take a call on such complaint, verify the records and say that no, this promoter is not following the requirement on 11, please cancel his registration. Then there's the appellate forum, they can go there, that's another part of the act. The section 12 says obligation of promoter regarding veracity of the advertisement or prospectus. So this also falls in line with 11, that you have to project in your prospectus, like in a company, everything that you propose to do, the little nitty-gritties, the quality of construction, the quality of materials that you are going to supply, everything has to be provided for in the prospectus of a project. Now, this act also provides that if a project has 5 phases, all 5 will have to be independently registered with the authority. It's not one, let us say, one enclosure. So one enclosure can be given permission, but there are 5 projects which are independent of each other, of the same promoter. Then you need to get them registered independently. Then after that, 14 says adherence to sanction plan and project specification. Now, this is a very interesting section. 14 would actually transgress into the municipal laws also. But this authority, which is overriding power, can also inspect and check whether they are complying with the municipal laws as sanctioned, the maps. Now, these are two different forums. The Municipal Act would also take care of this if somebody is not complying. Normally, a municipal building plan is sanctioned for 2 years or 3 years and can be renewed. But adherence to sanction plan means that the plan as sanctioned would have to be carried out to the last detail. So this is, again, section 14 gets a kind of overarching power which is given to the authorities under this act to say that despite municipal laws, we have a power to inspect and see whether you are adhering to the laws. Municipal authorities can independently come and cancel. But this also has the power to say that in case of any structural defect or any other defect in workmanship, quality or provisions of service, or any other obligation of the promoter as per the agreement for sale pertaining to such development is brought to the notice of the promoter within a period of 5 years by the allotee from the date of handing over possession. So it's after handing over possession also. Without any further charge, it shall be the duty to cure such defects within 30 days. Whether it happens on the ground or not is another aspect of the matter. Then you are entitled to claim damages under the normal civil law, the municipal laws, etc. Then obligation of promoter in case of transfer of a real estate project to third party, it is normally not allowed, but in a given case the authority may allow. So the third party steps in. For example, there is a corporate change in the corporate structure of the company. We have equivalent of section 391, 394 of the Companies Act, which is now under the new 2013 Act. There can be a restructure of the company, there can be a merger, demerger. So you have to just take permission of the authorities whether you can continue with that the company in the form that is now existing under the restructured formula. And then transfer of title. This is again very important because this is also a grey area. They used to hold back documents to say that transfer, we keep the rights over the land. We'll only transfer that transient portion of the building which is constructed to you. But this now takes care of, section 17 says, the promoter shall execute a registered conveyance deed in favor of the allotee along with the undivided proportionate title in the common areas to the association of the allottees or the competent authority as the case may be, and hand over physical possession of the plot, apartment or building as the case may be to the allottees and the common areas to the association of the allottees or the competent authority as the case may be in the real estate project, and other title documents pertaining thereto. So title documents would mean right to the proportionate share in the land also. That's my reading on this section. I may be wrong, but that is my reading, that when you transfer title, it means that it's a conveyance under section 17, which is mandatory registrable under the Registration Act, and therefore the conveyance is complete. You convey title to the property, maybe in bits and pieces, but the title becomes complete on the registration of the conveyance deed, which is entered in book 3 of the registrar of the registrar of documents. Then you come to return of amount and compensation. And this is where the compensation etc. comes in. If the promoter fails to complete or is unable to give possession of an apartment, plot or building in accordance with the terms of the agreement for sale, or as the case may be, duly completed by the date of specified therein, or due to discontinuance of his business as a developer on account of suspension or revocation, so and so, the promoter shall compensate the allottees in case of any loss caused to him due to defective title of land on which the project is being developed, etc. And if he fails to discharge any other obligation imposed on him under this Act. So therefore, if he doesn't do it, there is a penalty and compensation which is provided for under the Act. And so that the allottees is not left short of getting back his investment and an interest or by way of compensation. Normally section 70-74 Contract Act would govern how to claim damages. But that's a long story. If you go to the civil court, you just don't, a suit doesn't finish. We have suits which are coming to Supreme Court at the appellate level after 20-25 years. So a person who has retired, let us say at the age of 60, has to wait till 85-90 to get some decree enforced by the Supreme Court finally, because everything comes to Supreme Court. Even if a neighbor sneezes very hard, you can complain and FIR is lodged, it finally comes to Supreme Court. So the impact of the sneeze also is tested by a Supreme Court judge. But that's the way the legal system works in India. We have borrowed this concept of 136 from the Privy Council, leave to appeal, and it's opened up doors to, there are many a times they do a lot of good to society. So most of the time court time is taken up. Chief Justice is here, he understands what the impact, the docket 70, 80, 100 matters are listed before court every day. It is impossible. How do you assess damages? You have to have a proper trial, suit. Now, this takes a lot of time. Therefore, this Act actually takes care of most of these aspects for a willing purchaser of an apartment or a plot of land under a real estate program. Now comes the regulatory authority. So this authority actually governs the first stage of registration, of start of a project, of completion of a project. Now, if any complaint is made to this thing, like I said, the registration can be cancelled or they can monitor the development of the project within a time frame, which is largely within the contractual sphere. They take care of these. So section 20 onwards, there are members who are appointed. Now if, I digress again for a minute, this court has been confronted with non-manning of these tribunals or authorities by the numbers which are sanctioned or by the person who man it. So, R.K. Gandhi 1, R.K. Gandhi 2, there were two judgments which cracked down on the government to say that if you set up tribunals, you jolly well put up members also. Despite that, the government actually doesn't, to be very brutal, they are not concerned so much as to whether these are manned by competent people or not. But despite that, I find from statistics which I have taken from the website, at least the Maharashtra RERA I've got, the others haven't put up their statistics on both, that quite a few disposals have happened. Now, executability, I'll come to it later on. I don't find the executability impact or how they are going to do it because it's again under the provision of the CTC. So once you get into the Order 21 mode, in India they say that getting a decree may not be hard, but executing is the hardest bit. You actually run from pillar to post to get a decree executed. So then Section 35 says power of authority call for information, conduct investigations. So if someone kicks off this and complains to the authority, they have the power under 35 to come and conduct inspections and then put them in order. Then 37 says power to, 35 says 36 interim orders and 36 to issue directions. So these powers really take care of, if you remember, the Consumer Protection Act did not have the power to issue interim directions. So there was a judgment in 1993, Stanley Morgan, where different forums were granting injunctions. The Supreme Court finally told the legislature that you have to amend it and bring. Now they have a power to grant interim injunctions also. They also did not have a power of review, the Consumer Protection Act. That has also been introduced there. Now, powers of authority is also defined under Section 36. So they shall have powers to impose penalty or interest, which is largely in the form of damages. In regard to any contravention of obligation cast upon the promoters, the allottees and the real estate agents under this Act and the rules and regulations made thereunder. Then you come to 40. It says recovery of interest or penalty or compensation and enforcement of orders, etc. So it says if a promoter or allottee of a real estate agent, as the case may be, fails to pay any interest or penalty or compensation imposed on him by the adjudicating officer of the authority or the appellate authority, the case may be under this Act or the rules and regulations made thereunder, it shall be recoverable from such promoter or allottee or real estate agent in the manner as may be prescribed in the areas of land revenue. So this is a very common method of attaching their, let us say, official, their offices, their personal properties as an area of land revenue. So there is a system under every land revenue code how to enforce. So for example, there are dues with a person which owns to the sovereign. So how do you do it? You go and attach by meeting of terms, etc. Those are the old system which has been recognized as a effective method, and then they can attach that property and sell it to realize. So this is one of those. But this actually does not take care otherwise of completion of a building. This is only on the penalty aspect. So interest and penalty, which are like compensation, this can be taken care of under Section 40. Then you come to the appellate authority. There is the advisory council also. The appellate authority. So Section 43 says establishment of real estate appellate tribunal. This is where the appellate authority comes in. So the authority is the first stage of impact. The appellate authority is like a quasi-judicial authority, which would naturally have a retired judicial officer as the chairperson of the authority. So composition is under Section 45, and Section 44 speaks of application for settlement of disputes and appeals to the appellate tribunal. So if a person is disagreed by any direction given by the first authority, can apply under 44 to the appellate authority for settlement of the grievances. And the composition is like this: chairperson of not less than 2 and not less than 2 whole-time members, of which one shall be a judicial member and the other shall be a technical or administrative member. This is where I find most of these tribunals actually not able to take care. The pressure is always on the judicial member to, there are some active technical and administrative members, but they are not well trained in the nitty-gritties of law as we try and interpret, and as lawyers we also try to take advantage of little loopholes here and there. So that only a judicial officer, the pressure on the judicial officer manning alone is immense. So then he or she tries to convince his other members to say, if we want to write the judgment, factor it in this manner. But I must concede that some technical and additional members are actually very good, because as IS officers they also deal with some land acquisition, disposal of representations, etc. They determine the compensation, so they have some knowledge of how to take care of certain disputes. Then qualifications all set here. Then we come to the powers of the tribunal. Now here it says the appellate tribunal shall not be bound by the procedure laid down by the Code of Civil Procedure, so it's independent, but shall be guided by the principles of natural justice. So fair hearing to all, fair representation to all, as every court normally follows, because that's the first principle of law. Natural justice has to be followed. Then it has the power to regulate its own procedures or frame its own rules as to how the appellate tribunal is to proceed, and shall also not be bound by the rules of evidence contained in the Indian Evidence Act. So these are commonly found also in the Arbitration Act, etc. But a very conscientious judge or a tribunal would allow parties to lead evidence and also take care of certain aspects of legal aspects of the matter, so that a person doesn't go unheard or goes hurt saying that I haven't been heard properly or I was not allowed to lead evidence. But if the tribunal sees that no oral evidence is required, it may not follow the Indian Evidence Act in that sense. But presumptions, proof of a document, they also have to follow that, despite this subclause being there in the section. That is my reading of this act. And I think largely they are following this concept that give everyone a fair deal when they are before. It might be the promoter, it might be the allottee or the allottees. Then you have against the appellate authority, you have an appeal, statutory appeal to the High Court. Thank God we don't have this straight to the Supreme Court. That creates even more difficulty, because there's one stage is wiped out. And then you have a statutory appeal to the Supreme Court, and Supreme Court is bound. Finally it comes here. But from an authority, I don't think it's respectful to have a power given that you file an appeal straight to the Supreme Court. The High Court is well equipped to take care of all these. Most of the matters get settled there. Because by the time the promoter also realizes they're also losing time and money, because they have also taken their money is also stuck. A smart promoter will say, "Okay, I've lost some time." The allottees also lost some time, some compensation, and they negotiate and settle. So it might not reach the High Court also. Then you have offences and penalties and adjudication under Section 59, Chapter 8. This is a very important. This actually helps largely the allottee, but it also takes care to a certain extent the interests of the promoters also, because we can't always paint the promoter with the same brush. Some of them try hard, some of them because of COVID, because of the collapse of the financial sector, they actually went into bad times. But some unscrupulous builders took advantage. Therefore this act came. Now it says, if 59 says, if any promoter contravenes the provision section 3, he shall be liable to a penalty which may extend up to 10% of the estimated cost of real estate project as determined by the authority. And if he does not comply, then there is imprisonment and further penalty. Then comes penalty for contravention section 4, which is the project which has been projected to other people. Then other provisions of the Act is also provided for. Then penalty for non-registration and contravention in section 9 and 10. So if a person is not actually exempt, but still does not get it registered under the Act, the authority can go and impose a penalty on such promoter and developer. Then section 64 says, 63 says penalty for failure to comply with orders of the authority and by promoter. So this is only on the promoter. 64 says penalty for failure to comply with orders of the appellate authority by the promoter again. So because largely there are two things. One is if a allottee is not paying his or her share of installments, but they have a justification. They say no, the project is delayed. I do not know till I get the occupancy. I will not do it. So normally every agreement, the last clause would have that upon completion and upon receipt of the occupancy certificate, the balance amount is to be remitted. So it's called the fit-out stage, where a cold shell is largely given where you do your own works inside the flat, or most of the promoters now give a kind of built-up, super built-up with all chimney and ACs and everything fitted. But the last installment is normally after the completion certificate is given and the keys are handed over, and then the conveyance takes place. So this penalty is at that stage. So it says if any promoter who fails to comply with or contravenes any of the orders, decisions or directions of the appellate tribunal, he shall be punishable with imprisonment for a term which may extend up to 3 years. Now, while on this, there's a very interesting judgment of Supreme Court, again named Pioneer, which was under the Consumer Protection Act. And here, they also take note of the interests as granted by the RERA Act. And this is authored by Justice Indu Malhotra, as she then was. And it talks of unfair trade practice, etc., etc. And this Pioneer says that 10.7% simple interest, because you cannot have these one-sided agreements, which largely these promoters have. And this strike down the rate, because what happens, like I said, you don't have a contra interest. What happens if the project is not completed? These agreements don't provide for it. So this judgment, this is 2019 5 SCC 725. This is again entitled Pioneer. Here they actually follow the RERA concept of awarding a slightly higher interest, which is 10.7%. And they say that a term of contract will not be final binding if it is shown that the flat purchaser has no option but to sign on the dotted line. Now, if you go to take a car on hire, on lease, or let us say on finance, I believe you have to sign 64 times on the document. Now, tell me one, even a sitting judge, the most aware lawyer, nobody looks at the fine print because you want the money. So you straight away sign 64 times, you crisscross, finally at the end of the day when you try to sue them. And it has come to light now that a colleague of mine was trying to book a Toyota car. And the car finance agreement, you'll be shocked to hear that it had a clause which says that if you do not pay the finance in time, the financier will have a right to enter your premises, unheard of. If it's tested in a court of law, it will be struck down. But thankfully, the promoters don't have that kind of, deadly agreements. But they have agreements which are totally lopsided. So this RERA actually takes care of such. So that prospectus stage, your projection to the public as to what you're offering, what you're trying to give, when you're trying to give, is taken care of by this Act. This Act does not have the concept of unfair trade practice or negligence otherwise. It says if you fail to do. So failure is what is taken care of here. Unfair trade practice does not come under the ambit of this Act. It still remains with the Consumer Protection Act. So unfair trade practice is one provision which is consistently used by the Consumer Court to say no, this constitutes unfair trade practice, jolly will face the consequences. But this again, like Pioneer says, will survive or will be read alongside by IBC provisions independently, RERA independently, Consumer Protection. It's a choice of the person trying to sue. Then you can't then suddenly jump over and say, but IBC is again under the old winding up scheme of Companies Act. IBC is something which says now you have to try and first seek revival. In winding up the first one, if you can't pay, you are wound up. Today the first stage is gone reverse. You have to see whether revival of a project is paramount. Only if that fails and there's a timeline, then the project will go into liquidation. In that, that's why I mentioned that concept of CIRP, the reverse CIRP. That the promoter itself would come under this and project itself to the COC that I will do it. I'm sorry, there was some delay, some sacrifices the lending institution will have to make, and I'll complete the project. They may or may not accept it. Like I said, in my case, they did not accept it. Then there's compounding of offences also on payment of fine, and then you come to the finance accounts and audit. Those are not important. So when you see the operation of this Act, when you see the basic purpose of this Act, this is one sector which was largely unregulated. So an unregulated sector, people were groping here and there to find as to what do we do? I mean, where do we go? Like I said, a suit does not bear fruition before 20-25 years unless only persons compromise and they have a compromise decree. Consumer Protection Act filled up the gap and the lacuna to a large extent. And we must give kudos to the consumer courts to take a proactive charge. But then this came about. But despite this being notified in stages, the IBC stepped in, and if I may read those paragraphs from the IBC, the Pioneer judgment, there was a very interesting note by Mr. Shardul Shroff in the IBC committee, where he takes note of, if you have the do you have the citation of Pioneer judgment? No. It is 2019, 8 Supreme Court cases 416. So this is kind of peculiar judgment because it takes care of both. It takes care of RERA, which was still to be actively notified at that point in time because the tribunals were not functioning, the authority was not there. Then from page 453, it talks of sale and purchase of financial transactions, how they're defined. And then para 18 onwards, the law committee report and how the law committee factored in to say that this is what I was saying. Even the dissent of Chief Shroff recognizes that in the case of home buyers who have taken loans from banks, such banks ought to be in the committee of creditors. If such banks ought to be in the committee of creditors as representatives of the home buyers, they are to vote only in accordance with the home buyer's instructions. Why should the home buyer himself then not be on the committee of creditors, and why should it make any difference as to whether he has borrowed money from banks in order to pay installments under the agreement or otherwise? So they introduced section 25A to say that one representative from the home buyer would be a part of the committee of creditors. Now, how much of voting power he or she would have, it's not that one would represent 100, so therefore he would have 100 votes. It does not work that way. But at least they would have a say. And then right after para 18 to 20, they start with the Real Estate Act. And what the Supreme Court does is, at the end, compares both the acts. And while upholding the amendments brought to the IBC in 2018, the date was very important. It came subsequent to the enactment of the RERA. But then it tried to reconcile the two acts. And at para 30 actually says, as a matter of fact, the code and RERA operate in completely different spheres. The code deals with proceeding in rem, because these winding up and the company code actually are proceedings in rem, because it affects the world at large. This is to take place by replacing the management of the corporate data by means of resolution plan, etc., etc. On the other hand, RERA protects the interests of the individual investor in real estate projects by requiring the promoter to strictly adhere to its provisions. Like I said, you have to adhere to the provisions. So, and then the object of RERA is to see that real estate projects come to fruition within the stated period and to see that allottees of such projects are not left in the lurch and are finally able to realize the dream of a home. I'll stop here for a minute. The reason why this judgment says so is, like I said, if, let us say, the IBC fails, after section 3132 there has to be liquidation, mandatory. But even at that stage, we had an old section 466 of the Companies Act which says permanent stay of winding up. That means even at that stage, someone could come up and say, I will revive this company. Or the existing management would come up and say, see, under 391, 394, I have got this revised look at the working of the company. Here are the projections. The company court would permanently stay the winding up and allow that management or the third party to come up and revive the company. So this liquidation under the IBC also largely follows that. We have a provision which says that under 50, I think, that you can still come up and try and revive the project, though that timeline of 330 days has elapsed. But at that stage also, in the liquidation stage also, because what is liquidation? It means dissipation of everything that you have, and the promoters also saddled with cost. If the liquidation cost is not covered, then they can sue the promoters and realize from the personal funds. So it is at that stage that that provision has still not been tested on the IBC, because the IBC tribunals are largely disposing of only Section 7 and Section 9 applications. They don't even have time for operational and mismanagement matters. They're all left in the lurch. It's a daily bread and butter, Section 7, Section 9, admit, advertise, call the COC. It goes on like this. Is like a vicious circle there in the IBC, at least for the home buyer sector. It does not really serve the purpose. So RERA steps in. That's what that Section 30 says, that RERA operates in different spheres. Then you can come to the last bit of this judgment. The challenge to section 21(6)(a) and 25(a) in the IBC was also taken in. Then doctrine of reading down was looked into, and then the court finally comes to this conclusion that they will coexist, which is a very important paragraph. That is almost at the end of the judgment. This is Para 100, yes. Para 100, after noting everything but upholding those amendments to the IBC, this court says RERA is to be read harmoniously with the code as amended by the Amendment Act. It is only in the event of conflict of the code that the code will prevail over RERA. Remedies that are given to allottees of flat apartments are therefore concurrent remedies, such allottees of flat apartments being in a position to avail of remedies under the Consumer Protection Act, RERA, as well as the triggering of the code. And that's how the judgment ends. So this, according to this judgment also, seeks to be a complete code while giving directions to man these authorities and the appellate authority. Whether it has met the objective is still to be tested. It takes at least 10 to 12 years for proper statistics to come floating out, whether real estate allottees have got their just due, as we call it, and whether the promoters are still adhering to their timelines, their promises held out. Because, like I said, most of these projects, people just before retiring, or they have some money, they invest, they take some finance from banks. That's called process of subvention, where the project is still not taken off, but you are allotted flat 6A on the 6th floor. So that flat in the air is mortgaged to a bank who will lend finance to you, and that finance can be attached by the bank to say that so what if the project is not coming, they will enforce because you are not paying your installments. And the contra argument was, see, if I had the flat with me in the right time, I would have earned interest over it. I could have let it out, or maybe I would have used it. I was paying rent to some other place. So these are very complex web of intricacies where this act tries to step in and tries to fill the gaps. Whether it's complete, like I said, whether it's complete, it's really effective, only time will tell. But the intention of the legislature to take care of this sector can be appreciated. But the appreciation will be more if the tribunals function the way they are supposed to. Judges don't get up at 12, 12:30, 1 o'clock. They sit till the end of the day to see that at least 10 cases before it, in some form, are heard and disposed of. As lawyers, we can only put our best foot forward. We can either argue for an action under the IBC, we can only advise clients. We can argue under Consumer Protection Act, we can argue under RERA. I would say the way the RERA is structured, it seems to be something which has a lot for the allottees. And on that note, I would say there is a departure from the times before independence. If you have all seen Do Bigha Zameen, earlier people would pine to have a little plot of land with agriculture or even in the city because land was not scarce those days. As urban agglomeration happened, the boom happened after 70s, 80s, land became scarce, mostly in urban, which is also noted in Pioneer. And scarcity of land gave rise to such developers, and that made the developers take advantage of this situation, not all, some of them, to call for investments and then misuse that money and live a lavish lifestyle. The Supreme Court cracked down a number of Unitech, etc. as a case in example. Supertech, Unitech. Unfortunately, they have gone down under, but they had the wherewithal and the resources and their bank, which has now been attached. And it makes a very sorry state to see if you go on the Greater Noida highway, just structures standing like skeletons there. But what happens to the body? That even this RERA finally would not, you see, if a project fails, it fails. You only get back your money. And with that, the company actually goes down under. It has no money in its coffers because it is already spent here and there. It's a tall order for the allottee to really get their money back. It's all very easy to say we have laws, we'll enforce them, there's an enforcement guideline given here. But the actuality of the situation is, how do we enforce it? So enforcement under RERA is a separate chapter heading. Executability becomes the most difficult, like I said at the beginning. A decree is always welcome. You get the decree in your hand, it goes through various levels of challenges. Finally, when the decree comes to your hand, the litigant is actually so tired that they only want the decree to be executed, and then the real trouble starts. You have this, you have the third-party interest being created, you have the promoter having sold the property 3 times, 4 times to the same imaginary plot or the apartment, like I said, 6A, to maybe 2 or 3 aspiring buyers. So how do you reconcile all of them? So the Act also needs some reworking in I think, my reading of that. It needs to be more wholesome. It has to take care of very many. Like I said, unfair trade practice is not provided for in that. What happens if the project totally fails? A mere return of money, because prices escalate. A person who wants a project, like I said, a 1.5 crore apartment might fetch 3 crores in the market. But that person has taken a loan for 1.5 and is left high and dry. So to that extent, RERA does not actually answer the blank spaces in the Act, which will, I think, largely be taken care of by amendments. You see, legislation also functions on experience. Intention is correct. RERA is a very good piece of legislation, but how do you implement it is the biggest challenge in India. With the population boom, with the boom in demand and the ratio of demand and supply being so irrational in India, that people are either they just buy wantonly, or people who really want places to live and hide their heads, they just don't get redressal from the grievances. That's the way, because our court system is also so ill-equipped with the population pressure, with the number of cases and the number of judges. So everything is a vicious circle. So RERA seeks to step in to do some good for the society. How much of it is, after 5 years, if you have an audit of the RERA Act, then you can take a call on that. Thank you very much. I think I've stuck to my time. Yes, I have. I must thank...
Once.
One last word before you take off my mic. I must thank Mr. G.Seshagiri because his continuing efforts in different forms in trying to get young, even old advocates like us to learn every day. It's wonderful. This is a very great initiative. It's continuing from a long time. 30 is not a matter of joke. And so this is my third speech. Maybe I'll do a few more if he permits me. But then there are different subjects. And he actually selects a subject and he says, if you have anything else, you can please let us know. Which makes it even more beautiful, because then you start thinking about how to go about, because not everybody is an expert on every subject. Absolutely. We know, at least in Supreme Court, we're supposed to know we know everything. Yes. But the nitty-gritties of the working of an act, till you go into the fine line of the act, you actually don't work. The act is a very static thing. How you implement the act, how the courts look into the act, that's why we have appellate forums, we have the original forums. Everybody thinks differently. That's the beauty of law. So we should not lose sight of this. Thank you so much.
Thank you very much, Rana ji. So nicely explained RERA provisions and from 1950s Cooperative Society Acts to till date. Very highly grateful to you. This is the third time. So you has given entire the bare act of the RERA provisions and other. We are highly grateful to you. I request Rahul Agarwal will give a vote of thanks.
Good afternoon, everyone. So thanks for the beautiful lecture, sir. You enlightened us with the RERA provisions, with the IBC, with the consumer courts and civil courts as well. So you have taken us from the very beginning when this piece of legislation RERA was not there, IBC was not there. We used to file these civil cases. So it used to take long years and 25 years, 30 years till we come to the Supreme Court. Then the DDA came with the multi-story flats, and then the law evolved. Now we have RERA and IBCs. So RERA is you correctly said that RERA is the regulated, it's regulating the sector which is being unregulated, and it's trying to simplify the complexities in the sector. You have taken us to all the area with the RERA, like it is the welfare legislation, the carpet area is being defined in this, occupancy certificate is mandatory, and there are rules and there are set of regulations which the builder has to go through. Otherwise, RERA is there for the builders, for the buyers actually. The registration of the agents, functions of the agents, and there's a compensation provisions. Even it has offences and penalties. So we are very grateful, sir, for this lecture.
Thank you, sir.
Thank you.
Thank you.
Question now, questions please.